Good morning. Again, a complicated question in family personal law was whether family pension can be claimed by adopted son or not. So, this aspect is most vital for understanding what was the family definition of CCS pension rules. CCS rules are statutory rules being framed under Article 311 of the Constitution of India, because this pertaining to regularization and other procedure for governing central government employees. Here was a case that the one superintendent of the person retired in the year 1993. He had no issues, only wife. Thereafter, after the death of her husband, she, Maya Mudgore, adopted one Sri Ram Sridhar Chipurkar after 2 years. Then that man claims family pension on behalf of widow. That was allowed by the Central Administrative Tribunal, considering that some case means a case wherein the right of widower to adopt, that is called the Vijay Lakshmi Amma case. Vijay Lakshmi Amma sensational case wherein even after the death of her husband, she is entitled, the widow is entitled to adopt the any person. If she had no issues, or if she did not have male issues, she can adopt a son. She did not have female issues, she can adopt a daughter. That is a different personal law. That should not be confused with the claim of family pension. This is what Supreme Court says. AAR 2023 Supreme Court 618. AAR 2023 Supreme Court 618. Sri Ram Sridhar Chimurkar versus Union of India. In this case, several Supreme Court judgments were discussed. And further, Nositer Socis, NOSCATUR ASOCIIS maxim. That maximum says a phrase must be construed having regard to words immediately surrounding it. This is what they say under that doctrine and maxim. The Supreme Court has interpreted and read out the rule 5414B. The phrase in relation to a government servant would indicate that the categories of persons listed hereunder, such as wife, husband, judicially separated wife or husband, son or unmarried daughter who has not attained the age of 25 years, adopted son or daughter, are sought to be brought into association with the deceased government servant. That word has been specifically interpreted in the Supreme Court judgment. They say that deceased government servant should have maintained him. So the adopted son was under the shadow of a deceased government servant. Then only he is entitled for family pension. Therefore, since the Sri Ram Sridhar Chimurkar, who preferred SLP against the writ petition order which set aside the tribunal order granting family pension, the Supreme Court affirmed the order of the state judiciary. Therefore, here the case is very clear. Family pension claimed by son adopted by widow of government employee subsequent to his death, son or daughter adopted by a widow of government servant, subsequent to death of government would not be included within the definition of family under Rule 54 bracket 14 and B, and would therefore not entitled to receive family pension payable under rules. This is what they say. And finally, at the last page, it is also observed that the decision of this court in Vijayalakshmi Amma would not aid the case of the appellant. The said case is inapplicable to the facts of present case for the reason that the said case pertains the right of widow to adopt and right of inheritance of a child so adopted. So this adoption after being a widow on any person, here in the present case the government servant, she is having right to adopt under Hindu Maintenance and Adoption Act. But that would not entitle that adopted person for claiming family pension, because the phrase under CCS pension rules restrict the family. So since he was adopted after 2 years, it was the problem. So they would have preferred a different way for adoption deed. Some lack of intelligence in advocacy, blind procedure, simply gone through one particular judgment and jumped to agitate the case. Somewhat it is depends upon we can't find fault with the councils, whatever it may be. If I would have been the advocate engaged, I would have better ask any witnesses who could come and say that during the lifetime of government servant himself, the adopted son was brought up and there was some homam and other things are there. Only after the death of deceased government servant, the mother, the widow, would have registered it or created some other document formally. So that would be the fair better. Before that, therefore it is your duty that whenever you apply for any pension or compassionate appointment or whatever it may be, it is fair better that you go through the rules everywhere, wherever your claims rest within that purview of provisions of that rules. So kindly mind that these rules are called constitutional rules, statutory rules, because under Article 311, the union government and state government are directed to frame rules to regulate the services of state government and central government employees. Best wishes.